Good day, everyone. Today I will be discussing the case of Lascoña Land Company Incorporated versus the Commissioner of Internal Revenue, GR number 171251. In this case, the choices the taxpayer has in an event that there is inaction on the part of the commissioner or his duly authorized representative on the protest of the former were discussed. So before we proceed to the discussion of the case, here are some important provisions to take note. Section 3 of the Revenue Regulation number 12-99 dated September 6, 1999, which states that if the commissioner or his duly authorized representative fails to act on the taxpayer's protest within 180 days from the date of the submission by the taxpayer of the required documents in support of the protest, the taxpayer may appeal to the Tax of Court Appeals within 30 days from the lapse of the said 180-day period. Otherwise, the assessment shall become final, executory, and demandable. Next provision is Section 228 of the National Internal Revenue Code, which is about protesting of assessments. In this section, it's highlighted that if the protest is denied in whole or in part or is not acted upon within 180 days from the submission of the documents, the taxpayer adversely affected by the decision or inaction may appeal to the Court of Tax Appeals within 30 days from the receipt of the said decision or from the lapse of 180-day period. Otherwise, the decision shall become final, executory, and demandable. Now, let us take note of this provision of Section 228 because this will play a vital part in the deciding the case. So, let's proceed to the discussion of the case. Facts of the case. On March 27, 1998, the Commissioner of Internal Revenue issued a formal assessment notice to Lascoña Land Company Incorporated demanding the company to pay 753,266 pesos and 56 centavos of income taxes. Lascoña, on the other hand, filed a protest on April 20, 1998. So, but the Commissioner of Internal Revenue did not act upon such protest and instead promulgated a decision on March 3, 1999. Lascoña received a copy of such decision on March 12, 1999. Within the 30-day period, on April 12, 1999, Lascoña appealed to the Court of Tax Appeals. Now, the CIR moved for the dismissal of the appeal on the ground that under a revenue regulation issued by the BIR, which was discussed a while ago, if the CIR or its representative failed to act on a protest within the 180-day period, the taxpayer may appeal within 30 days from the lapse of the 180-day period to the CTA. Otherwise, it shall become final and executory, and that Lascoña having failed to appeal within the said period, CTA has no jurisdiction over the case. So, the CIR argues that because the 180 days had already lapsed from the filing of the protest, which was on March 20, 1998, Lascoña was just given 30 days from the lapse of the 180 days. So, his filing of his appeal to the CTA on April 12, 1999 was already prescribed. So, CTA argues that CIR argues that CTA already had no jurisdiction over the case because of prescription. On January 4, 2000, the CTA in its decision nullified the subject assessment. It held that in case of inaction by the CIR on the protested assessment, Section 228 of the NIRC should govern and not the BIR issuance mentioned a while ago. Section 228 provided two choices for the taxpayer in case of an inaction from the part of the commissioner or his duly authorized representative. Such choices are, first, appeal to the CTA within 30 days from the lapse of the 180-day period, or wait until the commissioner decides on his protest before he elevates the case. The second option was chosen by the Lascoña. Therefore, the CTA decided that Lascoña was able to file the appeal within the proper reglementary period. Dissatisfied, the CIR filed an appeal before the CTA. In the disputed decision dated October 25, 2005, the Court of Appeals granted the CIR's petition and set aside the decision dated January 4, 2000 of the CTA and its resolution dated March 3, 2000. It further declared that the subject assessment notice dated March 27, 1998 as final, executory, and demandable. On other words, CA opted to apply the BIR issuance instead of implementing Section 228 of the National Internal Revenue Code. So what did the Supreme Court said about this decision? So the issue of the case is whether the subject assessment has become final, executory, and demandable due to the failure of the petitioner to file an appeal before the CTA within 30 days from the lapse of the 180-day period pursuant to Section 228 of the NIRC. The SC ruled that the revenue regulation to which the CIR anchored its contention is invalid. Section 228 of the National Internal Revenue Code, which provides that a taxpayer has two remedies if the CIR failed to act on his protest within the 180-day period. These choices are: the taxpayer adversely affected by the decision may appeal to the CTA within 30 days from the receipt of the decision, or he may appeal to the CTA within 30 days from the lapse of 180-day period. So, this was the decision made by the Court of Tax Appeals, which was upheld by the Supreme Court. The Supreme Court denied the decision of the Court of Appeals to apply the BIR issuance instead of applying Section 228 of the National Internal Revenue Code, which is the law governing the protest of assessments. In the case at bar, Lascoña waited for the CIR to decide on the case, and it did not appeal within 30 days from the lapse of the 180-day period. In other words, Lascoña opted to choose option number 1 of Section 228. Lascoña received the adverse decision of the CIR on March 12, 1999, and it appealed on April 12, 1999, which is still within the 30-day period to appeal to the Court of Tax Appeals. The revenue regulation in question is invalid because in effect, it limited the remedy provided for by the law. Section 228 of the NIRC prevails over the said revenue regulation. The said revenue regulation cannot validly take away the option of the taxpayer to continue waiting even after the lapse of the 180-day period for the CIR to decide on the case and just appeal within 30 days from the receipt if the CIR's ruling is adverse. So, that's all, and I hope you understood my discussion, and I hope you learned something from it today. Thank you.